Good morning, everyone, and welcome to the next of CPLEA's webinars. Today, we're going to be talking about exercising your rights as a tenant, and we have two lovely guests with us today. We have Tim Patterson and Patricia Tolppanen, who I will introduce in a moment. And I will be your host today. I'm here at the CPLEA offices in Edmonton. If you're not familiar with CPLEA, CPLEA is the Centre for Public Legal Education Alberta. They produce print materials, online materials, as well as YouTube videos and other videos. And just so you know, the webinar will be recorded today and can be accessed at any time on the CPLEA YouTube channel. So if you're looking for more information on this topic, or you want to watch this video again or see it at a later date, you can find it on the CPLEA YouTube channel. Now, my name is Christian Gomes. I'm a second-year law student, and I'm here as a student researcher at CPLEA. I'm here once a week, and I get to host this wonderful webinar on this topic. And today we're going to, I'm going to give a little bit of an introduction on the topic and as well as our two panelists. And then I will turn it over to some questions on this topic, and we'll have both Tim and Patricia offer their knowledge, expertise, and insights on the ability of Albertans to exercise their rights through the processes that have been set up. So I'm hoping we'll gain some really interesting insight into those things from both of our wonderful guests. And we'll be going through those questions, and then we'll have about 15 minutes at the end as well for some question and answer with our panelists. So if you have any questions, you can look at the Q&A box on the Zoom, and you can enter your questions there, and hopefully we'll have time to get to all of your questions. We'll begin today with a land acknowledgement. The Center for Public Legal Education respectfully acknowledges that we are located on treaties 4, 6, 7, 8, and 10, and respects the histories, languages, and cultures of First Nations, Métis, Inuit, and all First Peoples of Canada, whose presence continues to enrich our vibrant community. I'll provide a little disclaimer on what we're going to be talking about today, which is that this presentation contains legal information and is not intended to be legal advice. There's also a few housekeeping items for today. We will be recording today's session, so all this will be recorded and posted on the YouTube channel, and you can watch that on demand anytime. It should be up within the next week or so. And then, as I mentioned, we will also have a Q&A period at the end. You can type your questions in the Q&A box throughout the presentation, and at the end, we will do our best to get to all of your questions. Also, when you exit today's webinar, you'll be prompted to complete a short survey about this presentation, and we'd kindly ask that you take a minute to do so to share what you learned today and other topics that you'd like to learn about. CPLEA collects that information so that we can better tailor our resources to the needs of Albertans. So if you can, if you're participating today, if you could please fill out that survey when you're done, that would be greatly appreciated. And we'd also like to offer a thanks to our funders. The main funders of CPLEA are the Alberta Law Foundation and as well the Department of Justice. So the goal at CPLEA, I'll just provide a quick overview. The goal of CPLEA is to make the law understandable for Albertans. CPLEA is a nonprofit organization that operates within Alberta, and we provide legal information and education in various formats, including web, print, resources, videos, webinars, operate a blog, and other things as well. And beyond sharing with Albertans what the law says, we aim to empower Albertans to use the law in their lives. CPLEA offers a bunch of different topics on their website. You can find all of this at cplea.ca. You can see some of the topics that are covered there as well. And I'll also offer another website that you can visit, which is lawnow.org, that publishes articles from some of the staff lawyers at CPLEA, as well as other people in the legal community on new and upcoming news and topics that relate to law in Alberta. And you can find all those things at cplea.ca. Now we're going to meet our panelists for today. So we have two panelists. Hopefully you can see them. And they have both graciously given their time and their expertise today to cover this topic. Patricia Tolppanen is qualified both as a lawyer and a chartered mediator. She's volunteered for close to 3 decades with the Community Mediation Calgary Society, helping neighbors resolve community-based conflict. Most of her paid work has been in the field of administrative law, ensuring that systems are fair for all parties. She worked for many years in civilian oversight of policing as the executive director of the Calgary Police Commission and of the Alberta Association of Police Governance. She then transitioned to provincial government, first as an investigator with the Office of the Alberta Ombudsman, then as an appeals officer with Alberta Employment Standards, and then as the director of permits and appeals. In early 2019, she took on the role of director and administrator of the Residential Tenancy Dispute Resolution Service, or RTDRS. She's based in Calgary but travels often to Edmonton, and in her spare time, she's an avid world traveler and likes nothing more than to be by or in the ocean. So please welcome Patricia. We're very grateful to have her here today. I'll also introduce our other co-panelist, Tim Patterson. Tim Patterson graduated from the U of A Law School and worked at a mid-sized law firm in the early part of his career before joining the Edmonton Community Legal Center, or ECLC, where he has been a staff lawyer for the past 14 years. His practice includes housing, including landlord-tenant law, employment, and human rights law. So please welcome Tim. We really appreciate you being here today and offering your expertise as well. So without further ado, we'll jump in to our first question. Our first question is, what are the rental issues currently facing tenants in Alberta? And I think generally we're seeing housing costs rising and a lot of issues arising out of that sort of the increased tightening of the sort of housing market. So I'll turn this question over to Tim, and maybe he can provide a sort of oversight of the issues that tenants are facing in Alberta right now.
Sure. So I come at this and all of the questions here from a particular perspective. I act for tenants in my practice. And so I see the problems that tenants experience. Now, I know for a fact that there's lots of tenancies that go smoothly and lots of great landlords out there as well. But I get to see the problems. And so that's the perspective that I come at this with. So as Christian said, I think, we are seeing some challenges emerge, particularly with the tightening of the rental market. I know that's the case in Edmonton, and I've heard that's the case in Calgary, and certainly in other centers as well. And it's in some ways, the smaller centers might be worse just because the housing supply is so small. And so if you are facing eviction from an apartment building in a smaller community, it can be quite difficult. And then with the rising rentals, if you lose your housing, then it can be difficult to find something that's affordable. And then I think there's a follow-on or a knock-on effect from that as well. I think that there's an incentive now for landlords to reconstruct or renovate their supply. I think a lot of the housing supply is quite old, and so there's an incentive to renovate, and so that higher rents can be charged. And so one of the things that I'm seeing a little bit in my practice is landlords trying to evict tenants. Some of them have been in a building for quite a long period of time in order that they can renovate and find new tenants to charge higher rent. And so there are rules around that, and there are certain circumstances where landlords are allowed to do that, and there are certain circumstances where they're not, and there's notice periods that apply and all the rest of it. So I think that's one of the challenges that I'm seeing, or I'm seeing that tenants are facing in the current market.
Thank you, Tim. I think I'll ask sort of a follow-up question to what you've just said there. Are all of those issues things that you see in your practice specifically? Are people coming to ECLC with those type of issues? Are they being, is it mainly that just their rents are rising and they're unable to afford things, or are they coming to you mainly with things like evictions or more emergent concerns?
Yeah, it's all of the above. I mean, I think that the issue of rents are rising, we won't necessarily see that until there's a problem. So until the rent has been raised and they can't afford the new rent. And so some of the legal issues that will arise from that is, well, was the rent increase appropriate? There are rules about when and how landlords can increase rents. So that's one thing that, as a lawyer, I can help a client understand is, was the landlord allowed to raise the rent? And were you given enough notice of that? But usually we only see it when a problem arises. So again, if a tenant can't pay that rent, they can't afford it.
All right, it looks like we may have lost Tim for a moment. That's okay. Maybe we'll move on until we get Tim back here. It seems he's frozen just briefly. So we'll move on from that question right now, and we'll perhaps move to the second question. Until we get Tim back. So the second question is, what are some of the barriers for tenants when trying to resolve these types of issues that we've just spoken about? And I'll ask Patricia if you could answer that while we wait for Tim to return.
Sure, and hopefully I'm not frozen, right? You can hear me and
I can hear you just fine.
Okay, good. I just want to start by saying thank you very much to the Centre for Public Legal Education Alberta for being an excellent legal resource for tenants and landlords in Alberta. It's an extremely important service that you provide and fits very nicely with my answer to this question, because one of the largest barriers for tenants when trying to resolve a problem is not understanding their rights and responsibilities under the law. And unfortunately, even though there are excellent resources such as CPLEA and also good information on the alberta.ca web pages that explain tenant rights and responsibilities in clear, plain language, not everybody turns to those resources. So I'm probably talking to the converted, because anybody who would sign into this webinar knows how to find CPLEA. But that's really the first place tenants should go when trying to resolve a problem, is find out what is the law with respect to the issue that they're dealing with. The next thing I would suggest is that tenants should really make sure they have a clear agreement, ideally in writing, with their landlord. And sometimes agreements change or are modified. And so make sure that all of that is very clear and well documented, because if it's clear up front, it'll prevent a lot of problems from developing or getting out of hand. Clear communication with your landlord is a great way to either prevent or solve problems. I would say tenants not reaching out to landlords directly necessarily, or making weak attempts to resolve things directly with their landlord. Ideally, that's where tenants should go first to resolve problems, is directly to their landlord, and see if they can sort things out on a cooperative basis. And then understanding the RTDRS process, of course, would be the final resort. So I wouldn't recommend people go to RTDRS as a first resort, but if the other avenues have not been successful, then not really understanding how the RTDRS works might be another barrier. And that's why we're here.
Yeah, that's exactly right. That's a perfect answer. I think what you've noted there is really important, which is that things like a court system or the RTDRS or any administrative sort of body like that is really intended to be an adjudicator, not of maybe last resort, but certainly it's best if parties can try to resolve issues and disputes on their own, either through their written agreement, like a lease or something like that, or just by communication between the two parties. So I appreciate that answer. I think that's absolutely true, and I appreciate the shout out to CPLEA as well. If you want to understand your rights rights and responsibilities as a tenant or just someone who works in the housing market, anything like that. As Patricia said, you can visit cplea.ca. We have a whole section on landlord and tenant law, and you can see a whole bunch of different resources. And I think we will also be posting some of those things in the chat as well. So you can access those things directly or on cplea.ca. All right, we'll move on to the third question. This is maybe one of the reasons I wanted Patricia to be here today as the director and administrator of the RTDRS is how exactly the RTDRS fits into the process of a tenant looking for resolution. So as Patricia said, it sort of already operates as ideally a body of last or final resort for landlords and tenants trying to seek resolution to one of these issues. But I also want to dig in a little bit to how the process works. I see we've just got Tim back as well. Tim, we've skipped a couple of questions in your brief absence there, but I'll start with Patricia again, and maybe Patricia, if you could sort of describe what the process of the RTDRS is, and how the body itself functions, that'd be great.
Yeah, I mean, if I were to describe how we function in full, we'd be here for well over the hour. But I will say I'm pleased to be asked this question because the RTDRS is very often misunderstood. So I'll start by talking about what we don't do. So we are not an advocacy service. We do not advocate on the part of tenants or on behalf of landlords. We do not investigate offenses, and we do not issue penalties or fines or charges. We don't hand people back money that they may be owed. We don't do any of those things. What we are is a quasi-judicial tribunal. And so we are a less formal version of a court, and we award remedies. And the remedies that we award are listed in the Residential Tenancy Act or the Mobile Home Sites Tenancy Act. So that's where you can find the remedies that you could apply for if you were going to apply at the RTDRS. So from a tenant's perspective, the remedies you can apply to the RTDRS for are return of the security deposit from your landlord, termination of the tenancy, if you think that's justified in law, damages or losses due to either the landlord's breach of the lease agreement or contravention of the act or regulations, compensation for performing the landlord's obligations, and an abatement, which also means like a reduction in your rent. So those are the remedies that tenants can apply to the RTDRS for. But by applying, we mean essentially filing a claim, very much like litigation would be filing litigation in a court. An application to the RTDRS means that you are asking the tribunal adjudicators to decide whether the landlord owes you any of those things that I just mentioned. And once that application is filed, I'll just try to be very brief about the process, then the application and any supporting evidence and the notice of hearing, and the hearing is like a trial, all of that has to be served on the other party, likely the landlord, if it's a tenant that's filing. And then the responding party has an opportunity to file evidence in support of their defense. They have to provide that evidence to the applicant, and then all of that is heard at the hearing in front of the tenancy dispute officer. And the tenancy dispute officer, who is the adjudicator, will consider the evidence, consider the law, and then make a decision as to whether the remedy or any version of it can be awarded to the applicant. Our process is less formal than a court, but it's the same principles that apply as in a trial. And so applicants have to prove with evidence that they are entitled to the remedy that they are seeking. And the burden of proof is on the applicant. The standard of proof is balance of probabilities. So it's not as high a standard as the criminal standard, but it still has to be proven. And so having things documented, as I indicated in the previous question, is an important piece of bringing applications forward. Testimony is also suitable evidence. So people that are bringing an application to the RTDRS have to make sure that they're organized, have to make sure that they have all of their evidence, whether it be records or testimony, clear and ready for presentation to the adjudicator. Yeah, should I stop there and let
That's great, Patricia. Yeah,
Tim jump
thank
in?
you. Yeah, I think a lot of great advice there, both on the format of the RTDRS and how someone might access it. But I do want to turn this question over to Tim, as well, as someone who advocates on behalf of other people in the context of this process. I think Tim has a unique experience as well. So, Tim, what does it look like for someone to file a claim under the RTDRS? Obviously, you've done that, helped people do that, and done that on behalf of people. If you could speak to that process a little bit, that'd be great.
Sure. And I apologize. I think I was having some internet issues on my end, so I'm glad I was able to at least resolve those for now, but hopefully we won't lose me again. So yeah, the question about how does the RTDRS fit into the process, you know, and I can get to the part where we actually file a claim, but I want to back up just a little bit. And I think it is important that, you know, both landlords and tenants try to resolve their issues before making an application, and that's usually going to be the best result for everybody, because it usually is the most efficient in terms of time. So, you know, I always encourage tenants to talk to your landlord about issues, and only when those can't be resolved and you need someone to step in to make a decision because there's a dispute, that's when it's appropriate to bring an application to the RTDRS. So from the tenant's perspective, you know, it's, you know, a fairly straightforward process. There's an online application process. So you can go straight from the website and create an account and start entering your information for the claim. You can upload any evidence that you want to use, whether that's documents. Of course, those have to be scanned in if they're paper documents, and then uploaded. I've seen video and audio recordings uploaded as well. They have to be in particular formats. That can be a challenge for some people. Like, there's a lot of people, of course, these days who are, you know, this is very easy to do. It's, you know, you're familiar with technology and it's something that you kind of do every day, and you live most of your life online. And there are other people that is much more challenging, and some of those are the clients that I see just because of the demographic of people that I serve. And so there is the option as well to do an in-person filing, at least if you're in Edmonton and Calgary. I'm not aware of any other offices in Alberta. I think those are the only two physical offices, but there is that opportunity to do an in-person filing as well. I think there's a couple of other options too, like fax filing. I think I've had to use that once or twice in a particular situation. So once it's filed, you get a hearing. You file it, you get a hearing date, then you have to serve it on the landlord if you're the tenant, and then the hearing date comes up, but it's a telephone hearing. And I think it can be surprising, I think, to some tenants just how quickly things go. Of course, the tenancy dispute officer is trying to balance, you know, efficiency of time, because there's not necessarily a lot of time set aside for each hearing. Trying to balance that with the opportunity to hear both sides and to make sure everyone has a fair trial or fair hearing. So, but the process kind of unfolds that way. Whoever's making the application usually goes first. They have to prove their case. The other side gets to present their evidence in sort of rebuttal. And then the tenancy dispute officer makes a decision at the end. And usually it's made right then and there. Sometimes they wait, but mostly it's made right then and there, and an order is issued. And I'm not sure if Patricia already talked about this, but those orders are enforceable. So once they're filed in the Court of King's Bench, they are enforceable as if they're a court order. So that's sort of how the process looks from an applicant's perspective.
That's great, Tim. I think that's some really valuable insight on what the process looks like. I think you both talked about a lot of steps, from filing to filing evidence to actually going to the hearing itself, and it sounds like it's quite an expedient process. But are there different timeframes for different types of disputes? And I'll put that to you, Tim. So if there's something like an eviction might be very immediate. So how long does this process take usually over the course of all those different steps? And how long could someone expect before they have a resolution, a binding resolution, like you said?
Well, I'll take a shot at it, and Patricia can correct me because I'm sure she's got access to better information than I have. But in my experience, eviction applications are prioritized because there's usually an urgent issue, and so those and I don't know what the turnaround times are. I would guess it's within a few weeks these days. Maybe it's a little bit longer than that, depending on what the volumes are. And then if it's what I would call strictly a money issue, so whether it's a tenant trying to get their security deposit back, or a landlord trying to collect damages from a tenant after the tenancy is over, those I think tend to get scheduled a little further out. I would almost hesitate to make a guess, but maybe months or a month or two or something like that. So, but Patricia can certainly correct me if my data is old, or my anecdotal data is old on that topic.
Yeah, thanks, Tim. It's funny, right? People love to spread bad rumors, but nobody really spreads good rumors. The good news is the wait times at RTDRS are very short right now. They're the shortest they've ever been. And so I know historically we've gone through phases where the wait time to get to hearing and to get an order may have taken a number of months. Excuse me. But presently, the time is pretty succinct. So if somebody is applying to terminate the tenancy, whether that be the landlord or the tenant, those hearings are taking place within 3 weeks. If the tenant has already moved out of the premises and one or other party is seeking to recover money, then those hearings are scheduled for about 6 weeks out. They won't necessarily be resolved in the first hearing. It depends upon the complexity of the issues and the volume of evidence that needs to be heard. Sometimes they can be resolved in the first hearing, and sometimes they may be partly heard at the first hearing and then adjourned to a later date. But certainly we are moving as fast as we've ever moved in the history of the tribunal.
I think that's really exciting and good to hear. I think, partially what we've talked about today is that the purpose of a tribunal like the RTDRS is to provide expedient resolution to these types of issues for a lot of people that are often very emergent and need quick resolution. And so it's really great to hear that the process is even faster. And Tim, I just want to offer or just get your view on one thing. If there's somebody listening to this who's considering filing an RTDRS or looking for resolution through the RTDRS, what types of evidence should they be putting forward? Should they be putting everything they have in writing, videos, pictures, everything, or should they be selective? And when you see someone come to you with a potential case, what kind of evidence is most effective?
So, I mean, it really depends on what type of claim the person is making. I mean, you really do want to tailor your evidence, though, to the specific claims that you have. And then you also want to choose, I think, your best evidence. And so what do I mean by that? So, you might have 300 pictures of, how clean you left the premises when you moved out. Well, an application for recovery of a security deposit is not going to be scheduled for a full day trial. So there's not going to be time to go through 300 pictures. So choose your best ones that show, what the state of the premises were. So I think you do need to be somewhat selective. On the other hand, you don't want to be under selective, because if you don't include it, you don't file it and you don't serve it on the other side, then you can't use it at the hearing. You can't sort of bring surprise evidence in. You know, there is a balance there. You know, if you're kind of working through the process yourself, you want to select your best evidence, but include it all of your best evidence, because you know, you don't always know what you're going to have to refer to during the hearing itself. So, and the types, as I said, it can be documents, it can be pictures, it can be videos. It all depends on what it is that you need to do to prove your case. And of course, most of your evidence is going to be what you say. That's your oral evidence. And so you don't need to have a document to back it up. It's always helpful, but I see sometimes people come to me and say, well, I don't have any evidence. Well, you have what you say, and that's good evidence. And if the hearing officer believes you, then that's can be enough evidence to establish your case. But it's always better, of course, if you have also either documents or pictures or videos.
That's great. Thank you for that insight, Tim. I think that moves us pretty readily into the next question, which is how lawyers fit into this process. Obviously, we've talked a bit about how the RTDRS is a bit more accessible than something like like the Court of King's Bench or something like that. And so I'll turn this over to Tim. How do you see lawyers fitting into the RTDRS process?
Well, I'll say they usually don't. I mean, I don't know what the numbers are, but
oh dear, looks like we've lost Tim again, just briefly. Well, that's all right. If I can,
he's back. He's back.
Am I back? Can you hear me?
Yeah, we can hear you.
Okay, sorry. Yeah, I'm having some. I just got a message saying my internet connection is unstable, so that's very true. I was just saying that lawyers are usually not involved in the process at all, and the percentage of cases at the RTDRS that lawyers are involved in are very small, and usually it's probably me or my colleague Sarah Eady as a lawyer, or maybe one of our students that are doing it. Sometimes there's a lawyer involved with the landlord, but not usually. And so I think where a lawyer is useful, though, particularly for a tenant, is understanding what your rights are and what you can do and what you can't do. So my organization runs summer legal advice clinics. And so people can, if they qualify financially, can come and get that advice. And I think that's very useful. That's a very useful role for a lawyer to have. And so if the person is able to proceed on their own, then, you know, the RTDRS process is very user-friendly from that perspective. Everybody's used to dealing with people who don't have lawyers in the system. So, you know, that's a good use of a lawyer. And sometimes I would say that if someone has a particular...
I'll just jump in if Tim's frozen again and say that people should not be worried about the fact that one party may have a lawyer and the other party does not. As Tim indicated, most people, like more than 90% of people that attend an RTDRS hearing are not represented by legal counsel. But don't be concerned if the other party is and you're not, because our adjudicators are very skilled at keeping the process balanced and fair regardless. So you don't need a lawyer to attend at the RTDRS. You absolutely don't. And it's not an advantage, I would say, except perhaps if you've got challenges with communication. So perhaps if you're not strong in the English language, having somebody who's informed about the law speaking for you can be very, very helpful. But other than that, legal representation is not a necessary part of the process.
Tim, you may have got cut off there. Do you have any final thoughts?
I think I was saying pretty much exactly what Patricia was saying when I was probably lost, which is, yeah, if there are particular barriers involved that a person is not going to be easily able to present their own case, but it doesn't have to be a lawyer either. Agents can appear as well. And so if you have like a law student or even a friend, someone who can help you present your case, then that can be a very useful person to have with you at the hearing. The other thing I would say too is that there are some cases I think that do have a little bit of legal complexity to them. There's an argument that needs to be made that's maybe a little bit new, or it's just not sort of obvious in the Residential Tenancy Act itself. Sometimes it can be useful to have a lawyer there to present that. But as we said, most cases proceed without the involvement of a lawyer.
I want to dig into that a little bit, Tim, as well. You've kind of referred to our next question is when should someone seek legal representation when they have a tenancy issue? So you just mentioned when there's a little bit more complexity or something novel within the Residential Tenancies Act that needs to be adjudicated by the RTDRS. Could you speak a little bit more to how someone might be able to identify when something novel is arising and when they should maybe seek legal representation rather than representing themselves?
So it's a little tricky, and that's why you need legal advice, I think, is that it can be a little bit hard to identify. I guess in general, what I would say is if there's a situation that presents itself that looks on the face of it like the rules are being followed, but there's just something that feels fundamentally unfair about it, there might be a different legal argument or approach that can be made. And so a quick example is if a landlord gives you a notice of eviction for a particular reason, and you think, you know what, I don't think that landlord is really being up and up with that reason. So it's one of the reasons is that is available under the Act and the regulations is if, you know, a landlord's relative or the landlord themselves wants to move in. If a tenant suspects, you know, I think this is just a ploy to get me out, I don't really think that's what's going on here. That's a bit more of a complex issue, and it would be good to get at least some advice about that to say, well, how can you make that case? And in fact, you know, can you make that case? Or if there's a rent increase that looks really, really big and it's only targeted at you and nobody else in the building, and they've given you, the landlord's given you a notice that complies with the notice that's required, there can be an argument that really what's going on here is something called an economic eviction. And a tenant can make that argument, and the TDOs know about that particular approach. And so you don't need a lawyer necessarily to present it, but it can be helpful to get at least some advice about that before trying to make that argument.
That's really good information, Tim. And I think what you're teasing out a little bit there is that there's a difference between legal representation and legal advice as well. You can seek advice from someone like Tim or another lawyer, and they can sort of tell you in what direction you might want to take your case. But you can also seek legal representation based on the nature of your issue or that sort of thing. Those things can be different as well. Patricia, do you have anything to add on what Tim has just said?
No, I think he's answered that question, which is well suited to his background. That's great.
Great, thank you. Something else I wanted to talk about, and this isn't specific to filing a claim, but I'm wondering if Alberta's framework for this looks different from other provinces, and if somebody's watching this from somewhere other than Alberta, do other provinces have something similar to the RTDRS? Do they have an adjudicative body like the RTDRS, or do they have a different system? And I'll turn that over to you, Patricia.
Yeah, definitely. There is a version of the RTDRS in every province and in the territories of Canada. And it's interesting to me as administrator for Alberta to notice that we are very similar, but there also are significant differences. So it's not done exactly the same way, but you know, we operate quite similarly, I would say. When the pandemic happened, the RTDRS went to exclusively hearings by telephone. Prior to the pandemic, we did some of our hearings by telephone if the parties involved were not located in Edmonton or Calgary. But if you were in Edmonton or Calgary prior to the pandemic, you were expected to come to an in-person hearing. Hearing by telephone has been extremely popular with the people that use our service. They find it makes the tribunal much more accessible. They far prefer the telephone hearings for a variety of reasons, and so that has become our standard. Many of the tribunals across the country do the same, but Ontario, for example, went to video conference hearings, and Tribunals Ontario did that for all of their tribunals, not just the residential tenancy tribunal. And that has proven to be a misstep. I think everybody acknowledges in that province that video conference hearings has actually drawn out the process and made it less accessible. Not everybody has access to the technology that would allow them to participate in a hearing in the format that we are using today, for example. Not everybody has the hardware or the software or the bandwidth to make that happen. And so it also is more labor intensive from the administration point of view to set up video conference hearings and you may or may not realize tribunals are conducting hundreds of hearings a week. And it's much easier to do that by telephone. So interesting to me, I don't know that Ontario will stick with video conference hearings long term, but technology changes and maybe it'll improve over the coming years. Different tribunals across the country order different remedies, and that just depends on what's in the legislation for that province. Some of the tribunals also have the enforcement piece built into their service, so that's not the case in Alberta. If an individual in Alberta wants the government to look at enforcing breaches of the Act that would be considered offenses, in Alberta, you would ask a different branch of our government to investigate that, and that's the Consumer Investigations Unit. So that's not actually the RTDRS. But I believe in some provinces, those two aspects are combined. In at least one of the provinces, I think it's Manitoba, they actually have a registry of all of their orders on file that you can pay to access. It's not a particularly large amount, but you would pay an annual fee, I believe, to have access to their registry. And in that way, you could search up the name of the landlord that you were considering renting from or the tenant you were considering renting to see if an order had been issued against them in the past. So that's a different aspect in another province. In Alberta, one of the things that we do that I don't believe any other province does, and again came about as a result of the pandemic, is we now file the orders on behalf of the applicant with the Court of King's Bench. And that happened because the court asked us to do that when the pandemic started, because the courthouses shut their doors literally for a couple of months. And so we started filing our orders on behalf of applicants at that time, and then we've just never stopped. So it's actually a lot of more work for our administrative staff here at the RTDRS, but it's an aspect of our service that people really appreciate, and the courts appreciate not having those people physically coming down to the courthouse and filing in person any longer, which they used to have to do. Yeah, so those are just some examples of how things might be a little bit different from province to province, but the essential aspect of being able to apply to a tribunal. Oh, I'll mention one other thing, which is that in some provinces, the tribunal is the only avenue to seek redress, such as applying for a remedy. But in Alberta, you can apply to either court as well, because we do not have exclusive jurisdiction. So, for example, I believe in BC, you can only apply to the residential tenancy branch if you're seeking an order against your landlord. But in Alberta, you could apply to the RTDRS, to the Alberta Court of Justice, or to the Court of King's Bench. Those are your options.
That's great information, Patricia. And I'll just note we do have a question that I'll bring up right now because I think it's relevant to this question that I'm asking here. And someone has asked whether the RTDRS will ever be returning to in-person hearings compared to the current telephone hearings. So if those on the call don't know, but most hearings proceed, as I understand, by telephone conference. Does the RTDRS plan to go back to in-person hearings?
I don't think so, no. So under very exceptional circumstances, if people think they need an in-person hearing for, and they would have to be special circumstances, as I say, they can request an in-person hearing. And the tenancy dispute officer will consider whether it's necessary. Ideally, you get the agreement of the other party that they too agree an in-person hearing is necessary. And then we would provide that either in Calgary or Edmonton. Those are the only two locations where we could do that, because that's where our adjudicators are located. But short of those what would have to be pretty special circumstances, as I say, no, the answer is no. We are going to continue with telephone hearings. All of our clients have indicated they far prefer them. They're much more accessible. They're easier to attend. People don't have to take as much time off work or off school. They don't have to get a babysitter. They don't have to get dressed up. They don't have to find parking. You know, there's all kinds of reasons why telephone hearings tend to be preferred.
Yeah, absolutely. And I think that's, maybe it was, Glenn, I appreciate that question, but I think, yeah, just like Patricia said, the telephone hearings are very easy for people to join into. And I know the point you made earlier about the video conference as well, that not everybody has access to the software, the hardware required to make a video conference happen as well. So Glenn, I hope that answers your question. This will move us, we're running a little late here, but I'll move on to our last question. And I'll direct this to Tim. And Tim, I wonder if there's any solutions that you'd like to see implemented. I don't really want to. I want to diverge a little bit away from the RTDRS and more. Are there things that you'd like to see in the housing tenancy situation right now? Are there solutions related to that you think ought to be implemented, and what can people sort of look out for when they're maybe renting from a landlord, and when they should bring that to the RTDRS?
Yeah, so I guess I'll start with sort of just the process question, and this isn't necessarily directed only to the RTDRS. I think it can also apply in other formats too. As Patricia mentioned, that you can still make an application in the Court of Justice and the Court of King's Bench. But I think there is a drive, and I understand why, to try to make things very efficient, because there's a big volume of cases to be heard. And I think I completely understand that drive and the need to do that. I do find that sometimes it's useful. One of the useful roles for me, if I'm involved in a case, is to slow the process down a little bit if I think that there's a nuance to the case that needs to be picked up. And I do know that I've heard quite often from tenants that whatever process they're in, they sometimes feel like they haven't been heard. And partly that's because they may not appreciate all of the issues in just how short a period of time that, whether a TDO or a judge or whoever's hearing the case has. But I do think it's important that as we think about how to make the system more efficient, that we don't sacrifice fairness for efficiency. And I'm not suggesting that anybody is trying to do that, or even that that's the case, but it is something I think that sometimes people have expressed to me, that just the speed of the process sometimes can feel like they're not being fully heard. In terms of more generally, I guess what I would say, if you're a tenant, learn about what your rights as a tenant are and your responsibilities, but learn what the rules are in terms of what a landlord can do and what notices they have to provide, and how long of a notice they have to provide in a particular situation. There's lots of different periods of time and different rules that are set out in the Act and the regulations. And so as much as you can learn about that, I think it will benefit you in terms of having a successful tenancy. And then the other part is what I've already mentioned, is like communicate with your landlord. That's hugely important. I think there's so many situations that I see that have come to a conflict because there just has been really poor communication on both sides, you know, from the landlord and also from the tenant. So I guess those are my sort of general comments.
Yeah, I think Patricia already alluded to that exact same idea, that if you're facing an issue like this, you know, the RTDRS is not supposed to be your first thing that you go to. You should go to your lease. You should go to the agreement between you and your landlord, and as well as just speak to your landlord, see if you can resolve that dispute between you two before having somebody else come in and make that decision for you. I think Patricia talked at length about that before. I'm going to go to some of the questions that we've had here. And I'll just sort of paraphrase some of the ones that have come in. One of the ones we had from a registrant was whether we have any resources for the most updated news about tenancy law rights, that sort of thing. I think our tech person, Matt, has put a link to some resources in the chat. So you can check those out. A lot of them are from CPLEA, and like both of our panelists have very graciously mentioned, that CPLEA is a resource that you can access for learning about your rights when it comes to being a tenant. And there's a whole section on the website devoted to landlord and tenant issues and law, that sort of thing. And you can also check out lawnow.org, where we publish different news articles from lawyers and other people in the legal community about that sort of thing. We've got another question here. Somebody asking on where they can find RTDRS decisions online. Maybe I'll put that to Patricia. Do you know where someone might be able to find decisions from the RTDRS?
Yeah, that's a great question. So the RTDRS doesn't have the obligation to make all of their orders public. That's not in our act or regulation, but we do publish a handful of written decisions, and neither actually are we responsible to put every decision in terms of the reasons for decision in writing. But we do put a handful of those in writing on CanLEI, CANLII is the website, and I'm trying to remember what it stands for, Canadian Legal Information Institute, I think. And they are the free library of all court and tribunal decisions across the country. And we now, RTDRS for the last 3 years or so, has been publishing some decisions there. The way we choose which decisions we are going to publish is based on whether they would be of interest, essentially, to more than just the particular applicant and respondent who were involved in that hearing. So if it touches on issues that might be of interest to other parties, could be educational for other people, because if they read it, they may say, okay, I can understand how those principles will apply in my circumstance, then we publish. So that's where you would go to find them. We don't publish the names of the individuals involved because, again, we don't have the obligation to publish. So we retract identifying information.
That's great.
As a lawyer, I love it when the RTDRS publishes decisions, because that's how we learn about what might happen in particular cases. So yeah, it's canley.org, and if you go to the Alberta page, because I use this all the time, and there's a list of different tribunals in Alberta, and there's an RTDRS one. You click on that, and then you can put search terms in. So it's really useful.
Yeah, that is a wonderful resource. Thanks for bringing that, Patricia. I'll note that Matt has also put that in the chat as well for anybody listening in. They've put the link, or Matt's put the link to CanLEI there, and you can find, like Patricia said, some of the written decisions from the RTDRS on there. We've had another question about issues arising between tenants and not between tenants and landlords. Tim, can you speak about sort of what process should be followed if someone is having an issue with another tenant rather than with their landlord? Is that something that you could go to the RTDRS for, or should they find a different avenue for that?
Yeah, that's a really good question, and one that we see all the time. So the answer is no. If you live with somebody else and you have an issue, say with another tenant, even if they're sort of the person that you're paying rent to, that is not something that falls under the Residential Tenancies Act, and therefore is not something that the RTDRS can hear. So you have to make an important distinction here. So sometimes if the relationship between the two tenants is not covered by the RTA, But the relationship between either of the tenants or both of the tenants and the overall landlord, that is covered by the RTDA and is something that you can go to the RTDRS for. So you have to be really clear about where, who is this dispute between. But if it's between two tenants who sort of live together, then you can't bring that to the RTDRS. You have to bring that to court. And that's also another reason why it's really good to have something called a roommate agreement with somebody that you are living with, that sets out what the obligations are, because otherwise it's going to be really hard to establish what the agreement was when the two of you moved in together. So, yeah, not something usually that you can bring to the RTDRS.
Thanks for that information, Tim. I'm sure that'll be very useful. I think that's most of the questions that we've received now, and I appreciate all of your perspectives on those issues. I'll do a quick plug here for CPLEA. So here on the screen is there some of the links that you can visit. You can visit the website, of course, at cplea.ca. And like I've already mentioned, a lot of the things we've talked about today, there's articles and information on the different types of rights, responsibilities that both landlords and tenants have. And you can find that under the landlord and tenant section of cplea.ca. You can also subscribe to the CPLEA newsletter. That's cplea.ca/subscribe. And that newsletter has all of sort of the new publications and the things that CPLEA are coming out with as well. And then you can also find CPLEA on social media as well under CPLEA Alberta. We post a lot of some of the news articles that are being posted, as well as advertisements for different webinars. We've had a couple webinars in the past couple weeks on things like AISH and adult interdependent partners, that sort of thing. And so if you're interested in any of those topics, please visit cplea.ca. There's lots of information on there. And then, as I've also noted, there is the YouTube channel as well, where this webinar will be posted, so the recording from this webinar. And just before we close out here, I'd like to give express my gratitude and CPLEA's gratitude for both of our panelists for being here today. Just to review, we've had Patricia Tolppanen from the RTDRS and Tim Patterson from ECLC. Thank you both for being here today and providing your information, your expertise, your knowledge. I think it's been very helpful, and I hope that everybody here today and those who watch it later can glean a lot from it. So thank you so much to you both, and we'll close things out here. I hope that's been helpful for everybody. So thank you and goodbye.
Thanks for inviting me.
Thank you.
Thank you both.